Good evening. Welcome. I'm Rudolph D'Souza, your host on today's webinar by MyNation Hope Foundation. Thank you for being with us today. We appreciate joining us on every Sunday on different topics and Men Ki Baat. Today we are discussing about a case which no media is ready to cover. Why we started Men Ki Baat? We started Men Ki Baat because our mainstream media is very much interested in publishing only women's cases or whatever complaints or stories, not men. You can Google it. You will not find many cases about men. Even NCRB says yearly 95,000 men are committing suicide. How many medias are highlighting? And half of the same amount of women are committing suicide, but those are highlighted in first page of all the media, and it's on TV. It's repeatedly coming, and women organization and other NGOs, women NGOs, ministries, they are promoting, saying women are only committing, ignoring men's suicide and other harassment, the false cases they are facing. Anyway, today we have a guest, Mr. Santosh from Guntur. In his case also, it's totally false. It's, from the investigation point to up to the final court, this thing, there is no evidence. Still, cases are filed, complaints are taken without evidence, without any grounds. Here with us, Mr. Santosh from Guntur. Mr. Santosh, please introduce yourself.
Hi everyone, this is Santosh. So, I'm a software engineer by basically in Bangalore. So as Rudy said, yeah, I'm from Guntur, but unfortunately, as you all know, we got into this legal cases, and it's like it's been years for me to start struggling with these cases and to prove my innocence in front of the judges and get the record out of it.
Okay, who filed the case? On which case filed?
So shall I start like when I got married and all that? Like which year I got
which
married?
which year you got married and what happened and what case filed and what is the reason behind it?
Okay. Yeah. So in 2013, in the month of May, I got married. But within a month period of time, unfortunately, that she had, due to some various reasons, she had left my company, and she just left to she left my company, and she was in her place. She was in her hometown, and after
After
6 months period of
how
time,
much months she left?
within it's like 1 month, 28 days exactly.
Okay, okay.
Yeah,
She was with you 1 month, around 2 months. Okay,
yeah, around 2 months. Correct.
okay,
So around two
okay.
months we stayed together, and due to various reasons, there is no concrete reason as such, but from her side, yeah, there are like many other reasons. So she
Yeah,
left my
false allegations, the soap stories, whatever they say, because when her you are not dancing as per her tune, for
exactly.
her it's a cruelty. Okay, what
Like,
they want a puppet. Okay, puppet. Whenever
that's
she says sit, you have to sit. Whenever she says stand, you have to stand and do the things what she order. Okay, they say like that. Whatever I
that.
order, you have to do. That
Yeah,
is their women word. Okay,
correct.
and you have to entertain her family. You have to give money to them. You should not give anything to your parents or your family. Okay, you should not
That is,
call also.
yeah, yeah.
Okay, if you are calling also, they will uh, listening, and then they will comment on that also. You are complaining, you are telling all this, all the everyone knows. It's nothing new in that. Okay.
Yeah.
Okay. She left after 2 months, and she went back to her place.
Yeah. She went back to her
Okay.
place, and after 6 months period of time, she started filing the first case is about the DVC, domestic violence case.
Mm-hmm.
Uh, there is no the report that got generated. There is no violence report or anything as such. The case got just filed, and the next
Mm-hmm.
day onwards, she has got an order of interim order of 2,000 rupees per month without
Mm-hmm.
even any inquiry. Before even
Okay.
I received the notice, I got to know that there is a interim order of 2,000 rupees per month.
Yeah, it's a normal trend. Even judges, they are not verifying
Correct.
she is eligible to claim a maintenance or not.
Exactly.
She
Yeah.
is most of the DV cases are filed just to show that there is a domestic violence. Without verifying it, it's a true or false.
Correct.
They are ordering the maintenance, interim maintenance ordered on the second date of all the cases. We have
Correct.
almost 10,000 members. We know how the interim judgments are coming. She filed
Mhm.
on this date today, and next date interim is ordered by default.
Exactly.
There is no trial of this court, no checking verification. Even Supreme Court says there are so many guidelines.
Correct.
The family courts, they are not obeying or following these directions. They straight away order. They act like a white knight to these women. You have to see these judges' faces when they're talking to these women. Okay,
Correct.
a smiling face, and wow, what a, they are thinking like they are doing favor to them. And same judge, when you're talking to men, you have to see their face. Okay,
Yeah.
there is no video allowed. Otherwise, if a video is allowed, then would have exposed every the milots of India. Okay, anyway,
Exactly.
interim is ordered. Then
Interim is ordered, and so immediately I appointed an advocate, and I started running through the trial. So after
Mhm,
1 year, after completing 1 year of my marriage, that is like
mhm,
2015 in the month of May, suddenly one
mhm,
day she appeared in my office in Bangalore.
mhm,
Suddenly started approaching in my office, and she came dressed up like a bride in a bridal getup, and directly she
mhm,
came and she bypassed all the security also. They couldn't even stop her
mhm,
because she's a woman. And
mhm,
finally, office boy he came and told me that somebody by name this girl like came to you to see you, and
mhm,
she's bypassed all the security violations and all. So immediately I came out
mhm,
of office and I saw her. So it's like I
mhm,
told her this is not the way to communicate because the cases are in court. And
mhm,
what is the point in talking out of the court now? Because when something is
mhm.
filed in the court, we just need to talk in the court itself. There is nothing else to
Yes.
talk about. But somehow
Yeah.
she said it's like a marriage anniversary and she want to spend time with me, which I
Mhm,
denied.
mhm.
Then later on,
No, no, she came with some plan. It's not a marriage anniversary. They don't remember all those things. They say it marriage anniversary. What date is there? The
correct.
prison date, or we have experience and from other members
Yeah,
experience.
correct.
They say it's like that day they are lost all the freedom. Their harassment is started. There is no marriage anniversary as such for Indian women. Anyway,
Exactly. Actually, what
okay.
you said is right. She came prepared for that. Outside, there are like
Mhm,
two Innova people waiting outside for me just to pick me up from
mhm,
my office to, I don't know whether to kidnap or something. But
mhm,
somehow I called my advocate and I asked him like, this is how the situation is, and she came to my office directly. Then
mhm,
somehow my advocate gave me like told me to leave the office premises immediately alone. That he
mhm,
told me that he had a doubt about her, saying that she would have come with people. So he told me to leave the office
mhm,
premises immediately. So once I left the
mhm,
office, then all the people I saw outside, they were like rushing to
mhm,
me to catch hold of me
mhm,
on the road itself. So the
mhm,
moment I saw them, and it's like, okay, I thought it is a well prepared plan, and immediately I left the office. Then my HR, my manager,
mhm,
all were watching all these incidents. I have told them that I'm leaving. This lady has come,
mhm,
and I'm leaving the office, and I'll come back in the evening again just to collect my laptop.
mhm.
They were all like, okay.
Okay.
They know me very well
Mhm,
from past 3 4 years, like how I work and what kind of a person I am. So there was very good
mhm.
support in my office. So
Okay, good.
it's like they told me, it's like, don't worry, we take care of you. You go, and they told me to be safe. So I left the office, and soon after, I left the office. They were like two people, a lot of people from two Innovas. They came to my office, approaching my HR manager, asking about me,
Hmm.
asking about my residence address. I started staying in a PG. Once she left my
Hmm.
company, I started staying in a men's PG just for my safety purpose as well.
Hmm.
So then she created a lot of ruckus over there, and
Hmm.
my HR, they couldn't tolerate all this nonsense over there, and they called police. So the
Hmm.
police had come and they had cleared the mess over there, and from
Hmm.
there directly they went to the police station, and they filed a
Hmm.
498 complaint
Hmm.
against me,
Okay.
my father, mother, my
Hmm.
brother, and sister as well, where they
Okay.
are nowhere in the
Okay.
picture. It's like 1.5 month. They didn't even stay with us. They are in different
Hmm.
parts of the state altogether, and
Hmm.
not even a single day they stayed with our company. But even then,
Hmm.
they had all our family member names as well. And this police station people, without even any inquiry or without even sending any notice to my family members, they have involved all those people names in the FIR.
Okay. No, what is the reason to file the case?
So the reason to file the case is, she cooked up a story saying that I actually assaulted her in my office. I didn't obey to come outside for marriage anniversary with her, for celebrating the
Hmm.
marriage anniversary, and I assaulted her.
Hmm.
In the written complaint, she told me that
She came to the office and she is saying you assaulted her. Okay.
I
If
assaulted her in
you
my
want to
office.
assault her, you would have called her to some remote place and you would have assaulted her. Why
Exactly.
you will assault when she come to the office when there is so many people around you? Okay,
There is a
that
CCTV
shows
footage.
how yeah, everything is videos are there, CCTV is
Yeah,
there, everything is there.
yeah, yeah.
Still she can claim, and police is not doing any inquiry. Okay, they
With
will
proof.
file
Yeah,
straight away file the case, and
yeah.
they can add additional sections also.
Exactly. 3 and 4 DP Act, everything is filed on top of that. 420,
Mhm.
498A, 3 and 4 DP Act. Lot of things they have added.
She trespasses your office premises. She breaching all the security rules. She came in. Above that, she is filing 420 and other cases on you. That shows how this our legal system is supporting and promoting them. It's not new. We have thousands of cases. Your case is not new.
Correct.
Still, we are just showing the world that how much bias towards men and support for these women from our police, our law, our judges, our ministers, our government, and our WCD and NCW. Anyway,
Yeah.
police did any inquiry after that also?
Nothing. They didn't even do any inquiry about my family with my family members, or neither me with as well. So they
Hmm.
directly one day they directly, after a couple of months later, they came to my office again. Only
Hmm.
police came
Hmm.
with for, not in a casual dress. They came to my office, and they called me outside the office. Somehow
Hmm.
I had a suspect, and I got this anticipatory bail done. Unfortunately,
Hmm.
that anticipatory bail period got over, and the
Hmm.
next day itself, the police were in my office.
No, no,
So
they knows. They will very well know. They will study because see, no police is. You are not a anti-national or terrorist or murderer. Okay,
correct,
for
correct.
this normal family problem, they are taking so much interest and coming all the way to the your office
Yeah,
on
yeah,
the next day of your anticipatory bail lapse
correct.
expired.
Yeah,
That shows they have bribe. Okay,
yeah, yeah. That I got to know. Yeah, true. They
and
got correct.
they are doing a favor
Hmm,
in return of that bribe. Okay,
correct. Yeah,
that is also not new to us. We know all these things. What police are doing is the
yeah.
police supposed to be first line of defense, but here
Exactly.
they are the one who start all this.
Hmm.
Okay, they have direction from top. When woman comes, you have to register FIR, you do anything
True.
to arrest a man and take action against him. So that's what they are doing. They
That is
came to
true.
your office as a personal favor to her because it's not there in anywhere police rules. Why they are
Correct.
doing? It's by default they took money.
They took money. Yeah, they
Anyway,
got bribed and they got influence
yeah.
from Inspector General. It seems. Later, I got to know they had told me personally that they are.
Mhm.
And this is how we got directed
Yeah.
to come to you and look
Yes.
into your case on a personal note.
Yes. Otherwise, why police will involve in such a
Exactly.
silly family matter?
That is true.
They are
Very
not
true.
going after the terrorist or others. They
Eh,
knows
yeah.
they cannot make money in that. Instead, they will lose their life if they follow terrorists or murderers.
Correct. That
Where
is
they
correct.
can make money, where there only they are following all those things and just to harass us. Okay. She filed the dowry case. Is there any financial transaction, anything she showed or any proof?
Nothing. There is no financial transaction. Actually, there was a land registration which is made on her name itself. Except that there is nothing else. I mean, that land registration also it happened on her name only. It's not given to me or my family members. So, and on top of that, there is no bank statements or no. There are some
Okay.
function marriage
Okay.
expenses. That's it. Except the marriage expenses, there is no give and take happened on the marriage day.
Mhm.
So we
Okay.
spent our own
You
expenses on
said
our.
the interim was awarded.
Correct.
On what basis it was awarded?
No,
Just because
we,
she is your wife and stayed with you for 2 months?
exactly. That is the only thing judge considered, and without even running the trial, she just
Mhm.
gave that order on the next day of the DVC file. That's it.
Okay. Okay. That means she showed there is a domestic violence and case is
Correct.
filed and
Correct.
without verifying interim is ordered.
Exactly.
That means
Exactly.
she filed the case to just to claim maintenance.
Just to claim the maintenance. That's it.
Okay.
So that is for just to claim the maintenance. She and during the trial, she even told the judge also that she wanted to live with me. She want to
Mhm.
spend rest of her life with me. And just that I am
Mhm.
not accepting her again. Just after filing this case, I told her I cannot accept you because you filed a case in the court.
Mhm.
Whatever.
Yes, whatever difference you have to settle it between
Between us,
yourself.
between four of us, right? I mean,
Yes,
we.
with
That is true.
your elders in front of elders or whoever
Correct.
seniors, not to go to the
Correct.
police or court. Okay, because
Court. Exactly.
they think they have the rights laws in support of them. They
Correct.
can show their capacity by filing a
Correct.
case. They can
Yeah.
say from sitting at home I can file a case on you, I can do this do that. We know many dialogues of these feminists what they are saying. Anyway,
Yeah.
uh, later your DV was dismissed, right?
Not only that, it's like soon after the 498, even then, I didn't listen to them. Police had called me and for the settlement. I said I cannot take her back because now she had
Mm-hmm.
filed me 498 as well. And she is clearly telling
Mm-hmm.
everybody just to threaten me and just to show me the other face of the law and how court supports and the law supports women. She just told me that this is how I can do whatever I want to do. I will do with you. So you have to listen and you have to take me back. That is what she had clearly told me in
Okay.
front of everybody.
Yeah,
I
that
said I
means
cannot.
she want to lead a happy married life by threatening you.
By threatening me. Exactly. She clearly told it in front of
What a
everybody.
joke. They
Yeah.
think
And
by threatening with the law, she can be happy because they want to silence you. It's not
correct.
a they can enjoy with other lovers. Okay, she wants someone to pay your bills, pay
That
her
is
bills. Okay,
that is true.
she can enjoy outside marriage because that is also now adultery is it's not a crime for women. That
Correct. Yeah.
also another blessing from our women ministry
Correct.
and our government.
Mm,
There is no adultery and you cannot charge her for sleeping with someone else
correct.
and you have to pay her bills, and if you are not paying her bills you are guilty, you are criminal. Okay, you're
Exactly.
branded as a criminal.
Mm.
Anyway, um, the
So soon after,
DV was dismissed. Judge penalized for filing case.
No, nothing like that. She didn't
Okay,
penalize her.
that means a judge also favoring and they are supporting false cases. And
Yeah,
even someone is filing false case, they will not penalize. Okay, unless you have a political some support or you are a big shot and they are
yeah,
making money out of that, they will not take a 340 perjury against a women
correct.
for filing case. That's why every woman is filing a false case. They knows nothing will happen to them. They will get public prosecutor for free. And you have to run post to pillar for your case, and they can threaten you with a legal option. They can do show their strength with the legal option. That's how our women NGOs and ministries empower our women.
Exactly.
Okay.
So she didn't even
How
penalize
these
her.
criminal cases impacted your career and whatever new opportunities you are getting?
Yeah. I mean, it impacted my career a lot. So I would say she didn't even stop with this filing this 498. Later on, a
Mm-hmm.
couple of months later, she again filed for maintenance, CRPC
Mm-hmm.
125. And after that,
Mm-hmm.
again, she filed restitution of conjugal rights again. So that
Mm-hmm.
just that she wanted to live with me and she wanted to come
Yeah,
back and
yeah,
stay.
that means she filed all the false cases. After that,
All
she
the
want to show that she is a saint, Sati
yeah,
Savitri. Okay,
exactly.
she is a good woman, Habla Nari, so she can claim more maintenance. That's how
Exactly.
it shows two side of same coin. Her two characters because she is filing case, and other side she is saying, "I want my husband." If she want her husband, she would have discussed with elders,
Correct.
sort out whatever marital problems they have. No,
Yeah.
instead she approached the police,
Yeah.
showing to show her strength and whatever legal option available for them. Anyway, you said because there was some extramarital affair or something was there.
Yeah, there are like
Uh,
multiple
uh,
things.
you you trying to convince judge and what happened to that?
Actually, I mean, during the course of trial, I got to know many things. One day, I was appearing to the court and I switched on the TV, and suddenly this girl showed up in the TV channel. Like doing some program. So I recorded the entire incident and I produced in the court again. Later on, one day, I found her roaming with a guy, and they got into one lodge. Okay. Then I went to the
Hmm,
lodge. I got all the details. I have showed the photo. This is the lady. She just entered into your lodge, and I need all the details. And I am her husband.
hmm,
And
hmm,
I am actually running through all these cases, whatever she had filed, and I need evidence
hmm,
from you. So they had
hmm,
clearly told me that they can't. They had shown me everything in the system, whatever webcams,
hmm,
check-in photos, whatever check-in photos they do, and whatever
hmm,
transactions they had made for how many days they have reserved room. Everything he had shown me, and he had shown
hmm,
me the ID proofs as well. So after looking at
hmm,
all those things, I have asked them, "Can you give me all this as an evidence?" They said
hmm,
they can't do it because it is out of their policy. It is like out of their privacy and all that breaches. And they said if
hmm,
I can send a notice to through court to the lodge,
hmm,
they said they will come
hmm,
and produce everything in the court. So
hmm,
while doing that, I got a lot of threats from the opposite party advocate and also from the
hmm.
judge as well. So my point is,
Okay, that means she influenced judge also.
yeah.
Okay,
So for the first
okay.
time, when I sent a notice to the lodge, it didn't go to him.
Hmm,
So
hmm,
what happened was the opposite party lawyer, they went to the office room, the courtroom. They whatever
hmm,
address I gave, they didn't put that
hmm,
complete address there. They have shortened
hmm,
it. They have removed that phone number and they gave a wrong pin code over there. They changed everything.
hmm,
So like that,
hmm,
it happened three times.
hmm,
After the notice again returns back to the court saying that it is a wrong address.
hmm,
So the second time, the judge has warned me saying that you are
hmm,
making severe allegations on a woman in our society,
hmm,
which is very wrong.
hmm,
So if at all
hmm,
I'm unable to prove the adultery on her,
hmm,
that judge is going to screw my life forever.
hmm.
So I
Yeah,
said,
yeah, that's how judges. It's not a threatening. They are doing favor to her,
never.
promoting this adultery and everything. It's not the people want. It's promoted and supported by our government, our ministers, our media, our society. Okay,
Exactly.
whatever they are doing, that's okay. This is Ablanari. Okay, she can do anything.
Mm.
We have list of murders committed by women, uh, but no one is listening. Media is not. They are publishing in last page of the paper,
When
and
nobody
TV
is listening.
also is a sideline. They will is not coming. Local media they are reporting. Anyway, here judges also they are supporting. They are acting like they are the savior of these women. Anyway,
Yeah.
still you had some electronic evidence also.
Yes, yes. I had this
Yeah.
electronic evidence, and later on, finally, what I did was I said, I will do a handover summons, and I said I took that order, I took the court order summons in a hand, and I came
Mm-hmm.
to Bangalore. I served it manually to the lodge people. The next day,
Mm-hmm.
the security team of the lodge, everything, they came up with all the evidence, and they produced
Mm-hmm.
everything in the court. That moment
Okay.
onwards, she disappeared in the court. There is no, there
Okay.
is not even
Yeah.
a
When her all false illegal activities
yeah,
exposed,
yeah.
they are like going underground.
Exactly. There is no not
They
even
think
arguments to choose.
they think no one can expose them,
Fine.
show
Mm.
the truth. When the show that when the truth comes in front of the world, they are silent. We've seen many feminists also online. They are coming to argue with us, and when we produce the proof and evidence and all the details, they are
Yeah,
silent. Okay,
true. That is true.
they are coming with the false statistics. All the this thing they have their own feminist controlled media, fake news. They do many things. Okay, when you go with all the evidence, because it's a good the hotel security team came with the evidence, otherwise if they influence them then they would have erased the
Yeah.
evidence also.
Evidence is exactly.
you,
Yeah.
you are lucky they came up to support the this thing.
Correct.
That's what I wish all those viewers watching us, listening to us, they have to support all these illegal activities. Unless you raise your voice, do something, nothing will happen. These feminists will ruin our India. They are trying to break our family system. Marriage is the backbone of our family system. They are hell bent to break this marriage and family system. Ultimately, they want to break whole India. Okay, they are going to lodge with someone else. They want to make uh, illegitimate, I can say, bastard kids, and future generation will be all full of bastard kids. That's what I want to say. But our law and our media, everyone is supporting them. Anyway, thank you for being with us, for your time. Out of all this, we prompted anything to you to say something, or it's all from your case.
No, it's not only that. It's like I just wanted to say she didn't even stop with that. She went ahead and she had sent notice to the U.S. Indian passport team for the U.S. embassies because
Mhm.
she just want to cancel my visas, whatever visas I have to
Mhm.
travel to
Yeah,
U.S.
that's not try to
Stop
harass
me,
you more.
yeah, harass me. She had
Yeah.
sent legal notice to my HR management saying that I am involved in all these criminal cases with 498 and all that. So she told me
Mm,
not to give any onset opportunities to me.
mm.
So, but anyway, my HR people, they know me very well, and they had put all those things in the dustbin, and they forwarded that legal notice to me, and they told me to put it as an evidence in the court, just to as an
Okay.
evidence from my side.
How she want to
Could
harass you
yeah,
and
obviously harassing
trouble
me
you
from
more?
the career side as well.
Okay.
Yeah.
No, no. Other than that, all this, whatever you said, we asked you anything to say like this, or it's from your case only?
No, no, this is completely from my case, and
Yeah.
all the judgments are also done now. I don't have any problem to. I just that I don't want to disclose the name of the party. I didn't tell it.
Yes.
Otherwise,
No,
I can
we have
even tell
no
the case
problem
number.
to, because this is a truth. We are not telling any false stories or
Exactly.
sob stories. It's a
Yeah,
truth. We are not afraid to tell our true whatever happened.
yeah,
Okay.
exactly.
We are not faking anything. This is not a fake. Okay, whatever this thing anyone want to verify, we have all the
I can give the
evidence in our
yeah,
system.
yeah. I can give the
Yeah,
case numbers. They can go to online and search the orders
yes,
as well. There is no
yeah,
issues.
yeah. We are not a fake like
That,
the feminist and our media is promoting the women, others, and false cases. Thank you for your time, Santosh. I
yep.
wish you will overcome all this and win your case. Uh,
Thank you.
Thank you for being with us and spend time. Thank
Thank
you.
you, Rudy. Thanks a lot.
Okay. With this, we completed our Men Ki Baat, today's Men Ki Baat. Anyone has anyone of you want to present your case like this, whoever faces false cases and harassment from police or our legal system or system, you can approach us anytime. Please visit mynation.net and contact any numbers. We'll host your case. Uh, with this, we are completed Men Ki Baat. Hereafter, we are taking our next session, legal section. Dr. Vikas, please continue. Dr. Vikas.
Yes, thank you, Rudy ji. Thank you, Santosh ji. So today our legal webinar is on important points in criminal trial. So our beloved Dr. Sarpali Prasar will give this webinar. He is a dentist. He is doing his final year PhD, oh sorry, LLB, and he is interested in matrimonial matters. So I would like to welcome Mr. Dr. Sarpali Prasar to start his webinar. Thank you.
Thank you, Dr. Vikas, and thank you, Mr. Rodolph. I was going through. I was listening to the pain of Mr. Santosh. I really appreciate him the way he fought his cases and never to die attitude. Well, today's webinar, maybe the title is not appropriately maybe it may look as if the title is not appropriately titled, but then as you go on you will understand why about the important points that normally both the defense advocates and the client miss out. The defense advocate may miss out because of two reasons. One is because of carelessness or lack of knowledge. Clients because they don't know. If the client knows, they can share it, right? Well, Dr. Vikas, we can start with this thing, with the PPT. See, evidence basically is of two types. One is documentary evidence. First of all, this is the disclaimer, which as we always say, the contents on this site is provided by users for your personal information only and is not intended for training purposes or carrying out legal proceedings. So you are see when you whoever is going through the webinar and wants to use it in their legal proceedings, they have to use it at your own discretion, right? So MyNation expressly disclaims all warranties. Okay, types of evidence: documentary evidence, oral evidence. Next slide, please. So you know what is a documentary evidence? Let's say there is a financial transaction, it becomes a documentary evidence. Or let's say there is a medical certificate, it becomes a documentary evidence. It is okay. Next, oral evidence. Oral evidence must be direct. In most of the 498 cases, it is based on oral evidence. So oral evidence must be direct. Oral evidence must, in all cases, be direct. That is to say, if it refers to a fact which could be seen, it must be the evidence of a witness who says he saw it. Let's say there is an allegation that husband has physically assaulted the wife. So who has to give an evidence? It has to be given by somebody who says that they have seen it, not somebody who the wife says that I have I have that my husband has assaulted me. I have seen it. Well, my husband has assaulted me and my daughter called me. It doesn't become a direct evidence, it becomes indirect evidence. If it refers to a fact which could be heard, it must be the evidence of a witness who says he heard it. Let's say husband has verbally abused the wife. Now, who should give a witness? It has to be witness has to be given by somebody. Am I audible?
Yes, yes.
Witness has to be given by somebody who has heard the husband verbally abusing the wife. If it refers to a fact which could be perceived by any other sense or any other matter, it must be the evidence of a witness who says he perceived it by that sense or in that manner. If it refers to an opinion or to the grounds on which the opinion is held, it must be the evidence of the person who holds that opinion on those grounds. Next slide, please. Hearsay evidence. Most of the witnesses in 498A cases are hearsay witnesses. So hearsay evidence means whatever a person is heard to say, it includes a statement made by a person not called as a witness, a statement contained or recorded in any book, document, or record which is not admissible. Hearsay witness may not be able to say correctly and completely the truth of his statement. Next slide, please. So, as per law, hearsay evidence is excluded. So, what are the reasons for exclusion? First of all, hearsay evidence cannot be tested by cross examination. It supposes some better evidence and encourages substitution of weaker for stronger evidence. Hearsay evidence is intrinsically weak. Evidence is not given on oath or under personal responsibility by the original declarant. What does the hearsay witness say? Let's say if it's a friend of a father of a wife. My friend told me that his daughter told him that her husband has assaulted or demanded something or assaulted or verbally abused. So it is third hand, it is not even second hand information, it is third hand information. It has a tendency to protect legal investigation. I don't know. My client saw, my friend told it. I don't know. As truth depreciates in the process of repetition, it is not reliable. Its reception will increase opportunities for fabrication. Next slide, please. Now, back. Exceptions. There is a slide for exceptions, Dr. Vikas. Exceptions to hearsay. Yes, there you go. See, the thing is, this is where most of the clients or advocates make a mistake, which is the exceptions to hearsay evidence. So the exception to hearsay evidence are the following five. Res gestae under section 6, admissions and confessions, relevant statements, evidence given in former proceedings, statements in public documents. Next slide, please. Now, what is res gestae? The word res gestae is used in section 6 of Indian Evidence Act. See, when you look at things, initially they seem as if they are interrelated. But when they are seen as a whole, you will understand that they are all interrelated. Facts which, though not an issue, are so connected with the fact in issue as to form part of the same transaction are relevant, whether they occurred at the same time and place or at different times and places. The rule embodied in section 6 is known as res gestae. Just a minute. Is usually known as rule of res gestae. What it means is that a fact which, though not an issue is so connected with the fact in issue as to form part of the same transaction becomes relevant by itself. To form particular statement as part of the same transaction, utterances must be simultaneous with the incident or substantially contemporaneous, that is made either during or immediately before or after its occurrence. The relevant case law, Bhairav Singh versus State of MP. Right, let me explain this. Let's say there is a statement by the father that our daughter told that on so and so date her husband has assaulted her. But then the father gives a statement in the FIR after 1 year or 2 years. Remember, read this statement. First of all, he did not see the incident, but then he told that her father told, that her daughter told, right? So normally, if you the court will say it is circumstantial evidence. It is not circumstantial evidence. The reason is the court may take refuge in res geste, stating that the father is the witness, is a normal witness to the cruelty meted out to the daughter, because if cruelty occurs in all the four occurs in the four walls. Who will give a witness? As a defense advocate or as a client or accused in a case, our defense is, if at all there was some cruelty, the statement would have been made immediately, if not after 2 years or 3 years.
Prasar sir,
Yes.
we have request from in YouTube. Can you speak little slowly because your voice is not very audible in YouTube.
Little slowly, is it? Okay, I'll slow down. See, let me repeat. Let me repeat this. Let's say the father of a wife gives a statement stating that my daughter told me on so and so date that her husband has assaulted her, has physically assaulted her, or verbally abused her, etc., etc., etc. And but then he gives a statement after 2 years. The affair is filed after 2 years, and then the statement is given, and there is no explanation for delay in lodging the FIR. In such scenario, the prosecution will say that father of a wife is the natural witness to the cruelty, because the cruelty happens in four walls. How can they get a direct evidence? It is circumstantial evidence. Our defense should be, if at all there was some cruelty, if at all there was some demand, if at all there was some verbal abuse, the FIR would have been filed immediately, not after 2 years. That's why, to form particular statement as part of the same transaction, utterances must be simultaneous with the incident. The statement should be given immediately after the incident, or at least within reasonable period, not after 2 years, 3 years, that too without any explanation for the delay in lodging FIR. Next. So, Sarkar on evidence summarizes the law relating to applicability of Section 6 thus. The declarations must relate to the act which is an issue or relevant thereto. They are not admissible merely because they accompany an act. Moreover, the declarations must relate to and explain the fact they accompany, and not independent facts previous or subsequent thereto, unless such facts are part of transaction which is continuous. Declarations must be substantially contemporaneous with the fact and not merely the narrative of the past. Declaration and the act may be by the same person, or they may be by different persons. Example, the declarations of victim, assailant, and bystanders. In conspiracy and riot, the declarations of all concerned in the common object are admissible. Though admissible to explain or corroborate or to understand the significance, declarations are not evidence of the truth of the matter stated. Next slide, please. Next thing, res geste. Section 6 of Evidence Act is an exception to the general rule, whereunder the hearsay evidence becomes admissible. Most of the times, hearsay is not, as we discussed before, in most of the cases, hearsay evidence is not admissible. So, res geste is one of the exceptions. But for bringing such hearsay evidence within the provisions, what is required to be established is that it must be almost contemporaneous with the acts, and there should not be an interval which would allow fabrication. As I have told you, once there is a delay in lodging the FIR, there is a chance of fabrication. The statement sought to be admitted, therefore, as forming part of res geste, must have been contemporaneously with the acts or immediately thereafter. Relevant case law, Sukhar was a state of UP. Next slide, please. Admissions and confessions. Under section 17 to 23 and section 24 to 30 of Evidence Act. An admission of a liability or confession of guilt which takes place outside the court is proved through the testimony of the witness to whom the admission or confession was made. Such witness is not a witness of fact as he has not seen or observed the main occurrence through any of his sense, but has only heard about it from the mouth of the party who admitted his liability or confessed to the guilt. Dr. Vikas, any questions?
Hi, Parag sir. Yeah, we have some questions. Can we take them now?
Yes.
Okay. Actually, like we mentioned, it is a criminal trial process. They have got questions from like a few related to criminal process and few in general. The
Yes,
first
go ahead.
question is like from Mahindra. He says like during mediation, the lady mediator has abused him, saying that she gave an example of the Prime Minister of India and his wife. I think she has actually like given him some counseling which is not required and tried to a bit be abusive on him. So in these type of cases, what can he do? Can he complain about her to someone, and where can he complain?
See, first of all, whatever is said and done in mediation is not admissible as evidence. That's what. Next question, please. I don't see any scope for complaining.
Okay. Yeah. I think we can keep searching for that, but as of now, we are actually like not clear on the options how to complain and so on. Okay. And the other question is from Kulbir Singh. Opponent filed complaint to PM office along with my brother bank account statement. What action can be taken, civil or criminal, or with Consumer Protect Act against the OP and bank? Actually, like opponent has actually filed a complaint to PM office where she has included not husband's but husband's brother's bank account statement.
See, first of all, there is a breach of trust by the bank.
Okay.
Right? There may
And
be a cyber crime there.
okay.
So first of all, he needs to book an FIR, and then he can seek
So
civil
it's a
remedies under
criminal offense.
It's a
Yeah.
criminal. It's both a criminal offense and also a breach of trust, and also a deficiency in service by the bank. So you can seek consumer redressal.
Okay. Yeah, he's asking like what action before going to police can be taken. We are surprised how they got his account number. Should we go for legal notice to bank first?
See, every advocate will have his own. Every legal counsel will have their own
They can
strategy.
file a case on bank. Hello. They can file a case on bank, the breach of privacy also, not only breach of trust, because they cannot share. If bank has given anyone account to the third party, it's a breach of privacy and breach of trust also, because he is the client of the bank. Bank cannot do all the sort of things just because someone is asking.
Yeah.
To justify.
Okay. And coming back to mediation, this is quite a general question. How many times mediation will be done? And if there are like multiple cases, will each and every case has the mediation? Like one in DV, one in 125, even before 498 is filed?
See, nobody can force you to go for mediation.
No, deviation is waste of time, because the most of the time nothing will happen to men. Okay, they only make you, force you, not make you, force you to agree to her condition. Okay, it's better finish mediation as soon as possible. No need to say 2, 3, or 5.
Okay, sir. Yeah, that's what we have for now. Please continue, Professor.
Next slide, please. Relevant statements. Statements by a person who cannot be called as witness. For example, a dying declaration. Statements which are mostly the statements of deceased persons who are not available as witnesses. The evidence of such statement is therefore the evidence of hearsay, and it is specially declared to be relevant. Next slide, please. Evidence given. See, Let me see. Most of the times there are multiple proceedings between a wife and a husband. Once there are multiple proceedings, because most of the case, see, when the case itself is false, and then there is a point that there is a point that they made some statement, the false accuser, no, the false accuser's lies were brought before the court. What they try to do is they improve on those statements. I mean to say, the next litigation. So how do you do? You confront them with the old statement. It is provided that evidence given by a witness in the proceeding can be used as evidence of the truth of the fact stated in any subsequent proceeding between the same parties, provided that the witness has died or is for some other reasons not available. Next slide, please. Statements in public documents. The statement in public documents, such as the acts of the parliament, official books, and registers, can be proved by the production of the documents, and it is not necessary to produce before the court the draftsman of the documents. Next slide, please. This is the most important thing. Most of the times, courts, either the defense advocate doesn't notice or the courts don't notice, but you have to see the way the witness behaves in the court. Section 280 of CRPC talks about demeanor of witness. Remarks regard respecting the demeanor of witness. When a presiding judge or magistrate has recorded the evidence of witness, he shall also record such remarks as he thinks material respecting the demeanor of witness while under examination. Sometimes there will be contradictions between the FIR and the 161 statements. There will be contradictions between the FIR and the Swan state and the examination in chief. As a defense, see, most of the defense advocates don't notice it. As an accused or as a defendant or as a client, you have to notice how the opposite party is behaving. That's very, very, very vital. Demeanor is not merely what someone says, but the manner in which it is said. Factors that contribute to individual's demeanor include tone of voice. Are they shouting, or are they sweating? How are their facial expressions? What are their gestures? How are they behaving in the courtroom? Make sure that if you find anything interesting, make sure that the court notes it. That is very, very, very vital. The term demeanor is most often applied to a witness during a trial. Demeanor evidence is quite valuable in shedding light on the credibility of the witness, which is one of the reasons why personal presence at trial is considered to be of paramount importance and has great significance concerning the hearsay rule. Sometimes, when you confront the questions with difficult questions, you confront the witness with the difficult questions, they will wait. They will, we call it tadabadu in Telugu. They will behave weird. Make sure that the court makes a notice of it. Court make sure that it is recorded in the evidence examination in chief that that the witness is behaving odd. It is not the behavior is not normal. Next slide, please. This is one of the judgments. See, because of the fact that there happens to be an inconsistency among written report as well as his deposition, on account thereof, he was directly confronted with a question which FIR
Prasar,
Sir,
Prasar,
network problem.
Prasad sir, we lost your audio.
Yeah, I had
Can
a
you,
network. I'm back.
can you
Because
repeat?
of the fact, I'm back. Because of the fact that there happens to be inconsistency among written report as well as his deposition, he was directly confronted with a question that which of two is correct. After keeping silence for a considerable time, are they silent? Are they taking time to answer? Lastly, the witness said whatever so stated by him in the court happens to be correct. Demeanor of witness is admissible in accordance with section 280 CRPC, and the evidence is to be pursued in the aforesaid background. The relevant case law, Sajjan Singh alias Ramakant Singh and others was the state of Bihar. So, as an accused, if let's say if you are an accused or as a defendant or even as a plaintiff, if the defendant is being cross-examined, be in the courtroom and stay attentive to the behavior of the witness. How are they behaving? They keep looking at sides, they keep looking at the roof, they behave all, you see all kinds of behavior in the courtroom. Make sure that it is entered in the chief examination. Next slide, please. See, in most of the cases, the court will talk say that the father of the wife is circumstantial evidence. How will we prove? There is no direct evidence. Circumstantial is evidence that relies on an inference to communicate to a conclusion of a fact. Remember this, in criminal cases, circumstances should be of conclusive nature and tendency, and that they should be as such as to exclude every other hypothesis but the one proposed to be proved. It must be such as to show that within all human probability the act must have been done by the accused. Next slide, please. Golden principles of circumstantial evidence. The circumstances from which the conclusion of guilt is to be drawn should be fully established. The facts so established should be consistent only with the hypothesis of the guilt of the accused. That is to say, they should not be explained on any other hypothesis except that the accused is guilty. Circumstances should be of conclusive nature and tendency. They should exclude every possible hypothesis except the one to be proved, and there must be a chain of evidence so complete as not to leave any reasonable ground for the conclusion consistent with the innocence of the accused, and must show that in all human probability the act must have been done by the accused. Remember this. If you don't present all these things before the court may say that, if you see, understand this, the basic principle of criminal trial is that you should, as an accused, if let's say you're an accused, you should go with the presumption that the court doesn't know anything. As either if you are doing in person, you should make sure that you write the best possible arguments, you make the best possible cross examination to show that you are not guilty. Yes, the burden of proof is on the complainant, but still is on the prosecution. But then you have to do your part. Don't leave any ground for the court to take refuge in circumstantial evidence. You have to rip it apart. Next slide, please. Importance of defense counsel in trial. During chief examination of witnesses, prosecution always tends to load its evidence with leading questions. As per section 142 of Evidence Act, the court should not, the public prosecutor should not ask leading questions except with the permission of the court. And for that, if you are in person, you have to be in the chief examination and you have to oppose leading questions by the public prosecutor. There may be possibility of even adducing hearsay evidence, introduction of irrelevant and inadmissible documents. A trial judge cannot be either on the side of the prosecution or on the side of defense. He is neutral. In such circumstances, it is imperative that a counsel on behalf of the accused or defense shall present or participate in the trial proceedings. Note down the demeanor of the witness and draw the attention of the sessions judge to this aspect. Object when prosecution put leading questions to the witness, when prosecution adduced hearsay evidence and tried to introduce irrelevant and inadmissible documents in evidence. Next slide, please. So the presence of a defense counsel at the very commencement of the trial as well as till completion of the trial is very important. It is part of the right of the accused persons under section 303 of CRPC. Read with article 22 clause 22(1) and 21 of the constitution, and section 304 of the CRPC. Read with article 39A of the constitution. Relevant case law S. Yuvraj versus State. This is a judgment by the Honorable High Court of Madras. Next slide, please. Right, I have some more data to add here to talk about interested witnesses. We have a false notion that relatives of wife are interested witnesses. They are not interested witnesses. So I have something to say. Who is an interested witness? Like, am I audible? Am I audible?
Yes, yes.
Yes.
Right. Who is an interested witness? Interested witness, a close relative who is a natural witness cannot be regarded as an interested witness. Interested witnesses, the term interested postulates that the witness must have some direct interest in having the accused somehow or the other convicted for some animus or some other reason. Kartik Malhar was a state of Bihar. As per English Law Dictionary definition, who is an interested witness? An interested witness is a witness in the trial who has a personal interest in the outcome of the matter and has some kind of material stake in the outcome of the case. So if you are an accused or if you are the defense advocate, you have to show that the relatives of the wife have some reason to get you convicted. If you are the accused, to get you convicted. If you are the defense witness, to get your client convicted. If you are able to prove that, then you can say that the relatives of the wife are interested witnesses. Further, in Sahabuddin versus State of Assam, it was held that an interested witness is a biased witness who aims to falsely implicate the accused. Testimony of such witnesses should be analyzed with caution for its credibility, as duly laid down in Gangadhar Behera versus State of Orissa. So, when analyzing the statement of a witness, there are three factors that you need to consider. Witnesses access to, how did the witness act? Witnesses access to correct information. Witnesses motive behind hiding the truth, if any. Whether witnesses agree in their testimony. It is an uncontested fact that the testimony of an interested witness lacks reliability and mandates corroboration for its acceptance. It is well settled that interested witnesses desires conviction of the accused. Therefore, due caution and judicial approach is a must when taking such testimony into consideration. Relevant case law, State of Haryana versus Shakuntala. Remember this. Remember the case law for the contradiction. Question concerning reliability and credibility of testimony of interest has been answered by the Supreme Court in Joginder Singh versus State, where it was held that mere relationship cannot discredit the statements given by an interested witness, provided it gets sufficient corroboration, as was reiterated in State of Bihar versus Shaukat Mian, as follows. Its credibility cannot be doubted merely because he was an interested witness. Evidence of interested witnesses shall have to be tested with caution. Moreover, an interested witness who is the relative of victim would be the person who is keen to ensure that justice is done to the victim. So, to conclude, I want to say something. The relatives of wife initially are not interested witnesses. Don't take their evidence lightly. You have to do a proper cross-examination. If you are the client, you sit with your advocate. Make sure that those questions are written. Shall come out with all possibilities and hypotheses. Number one. Number two, if you are doing a cross-examination, don't give a chance to the opposite party to explain their version. It should always be a yes or no. There is no other option. Thank you.
So, Processor, we have some questions on YouTube.
Yes.
Okay, here is one of the question. Can the FIR and the charge sheet contradict each other? Contradict in the sense on the narration of the incident or the incident details that has been mentioned in the FIR and the charge sheet are different. Sometimes not mentioned in FIR are actually brought in the charge sheet.
Is he referring to CRPC 161 statements by any chance? If he's referring to CRPC 161 statements, okay, because CRPC 161 statements are part of the charge sheet. See, that's why I was talking about demeanor of witness. When the case comes for trial, one question, let them see. Once they have improved from the FIR to the charge sheet, CRPC 161 statements, they will definitely improve in their evidence examination in chief. Once that is done, use it. Use CRPC 280. Contradict them. What is true? Is your FIR true, or is your evidence in chief true? Let the court make a note of the demeanor of the witness. Use it to your advantage.
Okay. Actually, in this case, what happened is after the FIR is filed, because the FIR is absolutely frivolous and whoever the alleged accused are there, they did not even meet the girl in their lifetime. Because of such a nature of false frivolous charges, they immediately has gone for quashing of the FIR. They don't even stay in the same country. They are actually from two different countries. So there is no possibility of them meeting each other.
Okay.
And they have actually provided those evidences like these are our passports. We have never come to India and this girl has never stepped out of India and so on. So based upon those evidences, can the wife actually change her narration and come up with the new charges? Oh, they did not actually come and hit me, but they have actually hit me through phone. Like they were shouting me on mobile or something like that. So if those type of things are done in the charge sheet, which we call as improvisation and so on, how to actually contradict them, or like what exactly are the options
if you're talking about quash, if you're talking about discharge or quash, you cannot use it, right? But if you're talking about trial, because the current topic is criminal trial, it's their burden to prove. Why are you worried? I mean, whoever it is, why are they worried? Use demeanor of witness.
Okay. We have one more question from Balaji. At what all stages can the evidence be filed? Actually, like if you can quickly say about on a high level, what stages of criminal case will be there, and at what all stages evidences can be marked or evidences can be
CBI
submitted.
versus I would take the reference of this case called CBI versus RS5. It says evidence has to be filed at the time of investigation. But then the apex court says, see, there's a difference. Criminal trial should not be used to fill the loopholes of the prosecution case. But then it can be used to support their allegations. So there are two stages. One is at the stage of inquiry, and at the stage of investigation. Give whatever evidence you have at the time of, let's say you are the prosecution. You will give whatever evidence you have at the time of investigation. The second stage is there's something called evidence stage during trial. After case documents are given to you under section 207, and then charges are framed under section 240 of CRPC. After charge framing, the court will send summons to accused, summons to witness, and once summons to witnesses are sent, witnesses will come. They can definitely submit new evidence during trial. But then, as a defense advocate, you have to oppose. What were you doing? Why didn't you submit it? It's a false evidence. You have to oppose.
Yeah, we oppose, but actually by book they were allowed to submit evidence if at all, if it appears,
if it is relevant, if it is admissible.
If it is relevant and admissible, yeah.
and yeah, relevant and admissible. Yes.
So till what stage can that evidence be? Even in the appeals also, will they add new evidence?
Appeal, let me tell you, CRPC 391 says that in rarest of rarest circumstances, new evidence can be added, but it rarely happens.
Yeah. Okay. So the other one is we were mentioning about listed witness, interested witness, legal witness, prosecution witness. Can you actually define each one of them and at which stage a
Listed,
legal witness
listed,
like become?
listed LW. There are two terms here. One is LW, the other one is PW. LW is
Yep.
listed witness. Listed witness is a witness listed as a witness who may be a witness in the charge sheet. The moment they come to court and give an oath, they become prosecution witness. That's what.
Okay. And we have one question from Surya. Can the evidence or witness be brought in who are not mentioned in FIR or in the charge sheet or none of the 161 CRPC statements from any of the members who listed in FIR has mentioned their names?
See, the thing is, that's why I said
Counter
irrelevant,
it.
new, yeah, counter it. Why didn't they mention it? They let them give a proper explanation. Let the prosecution give a proper explanation for not listing them during investigation stage.
Yeah. So what we say is if we don't challenge, there are at many stages where they can keep on abusing the process of criminal trial
That's what
because the
prosecution does.
process of yeah because the process of criminal trial allows lot many things as exception cases. If we don't challenge it enough, then yeah, those exceptions might be turning in their favor.
Yes.
Okay. Regarding the charges that are maintainable for 498, can
Hmm.
relatives who are like the allegation itself is the cruelty has been over the phone. Uh, so does 498 even gets applicable for that sort of allegations?
One thing, what was the cruelty for? See, if it was, see, I'll tell you what. Normally, what they do is they abused me. See, if it says they scolded me, they asked me why you are not doing household work. Hmm? If allegations are like that, then it is not 498A. But if you say if you don't give money to your husband, okay. So dowry demand was for the husband, not for them.
Okay.
There you go.
Okay. And coming to the interested witness, sometimes the relatives of the opponent will come in our favor.
Hmm.
Might be because they actually had some fight with them, or they could be really a genuine persons who want to stand with the truth. So that's the
Hmm.
reason they come and stand with the husband. So in those cases, how will it normally be? And if at all, if relatives of husband who are having some other family fights with them, if they go and give uh, like in favor of opponent or
See,
wife, how will it be considered?
let me tell you one thing. The basic principle of criminal trial is that don't ever, never, unless it is very, very vital, don't give the defense witness in a criminal trial. If they are listed as prosecution witness, let them turn hostile. There ends the matter.
Okay.
Because we know how police work.
Okay.
The witness would have said something. The so-called prosecution witness would have said something. They would have written something else. Only to they write only whatever is in the favor of the prosecution.
Hmm.
So simple. Let me
So
tell
if
you
we have to
something.
prioritize,
Yeah.
first thing is we have to actually like break what all the allegations and the evidences that they are bringing up, and only if it is necessary we have to actually add our defense witnesses.
Yes.
Okay. And the next question is, can new witnesses be brought in criminal trial who were not summoned or mentioned in the case diary? I think
Definitely.
it's similarly as above. Okay. Can the complainant herself be an interested witness? Actually, what's the status of complainant? Will she be considered a complainant, or her whatever her gospel words will be considered as truth? Or
See, thing is this: if you don't oppose, it will be considered as truth.
okay,
You have to show that the complainant is an interested witness. Reason is, I will send you to jail. Definitely, in 498 cases, they would have understand this boss. It's a mind game. I'm sorry for using the word boss. It's just that it's my whatever you call it. Okay,
yeah, yeah,
Ramesh.
ignored. Yeah, ignored.
Okay. So the thing is, you have to show the demeanor. That's what I'm telling. Make the court, let the court make a note of the demeanor of the witness. That's why it's very, very, very vital to sit with your counsel for cross examination. Check out all the pros and cons. Check out all the permutations and combinations. Number one. Number two, don't give a chance to explain. Now, don't ask questions that will work against you. So, because the topic is important points in criminal trial, I would recommend few books. There's one book called Speedy and Fair Trial from Lawman series. Number one, I would recommend everybody to buy it and read. Number one. Number two, defense and dowry cases. Number three, the art of cross examination. Read those three books, and you will be, I'm sure, because the accused knows better facts about the case than the counsel, they will be able to guide the counsel better.
Sure. We have just two more questions.
Yes, go ahead.
A husband has called father-in-law and complained about his wife that she wishes to drink and sleep with another man and all of that thing. So this father-in-law has actually recorded that call. Husband's phone got snatched and formatted. If this audio is actually presented in the court, what can be the options that the husband has?
See, he did not tell it to some Tom, Dick, and Harry, right? He told his father-in-law. He asked him to counsel her. There you go. So it's actually in his favor rather than against him.
Okay. And we have another question. Criminal trial of senior citizen parents located in faraway places. How to safeguard them, and how to actually make petitions for their absence.
There are three options. One is CRPC 317 petition. Number one. Number two, if they have health reasons, CRPC 205 petition are asking for permanent exemption. Number three is file a petition under file an application, not even a petition, file an application under section rule 37 of criminal rules of practice, stating that one accused will represent everybody else. There is a matter.
In DVN 125, when to give evidence by respondent. This is the defense witness or defense evidences with written statement or evidence stage. Hello? Hello, Prasad, can
Interim
you hear me?
maintenance, and the wife is working. Yeah, I can hear you.
Okay.
If the wife is asking for interim maintenance, okay, and the wife is working, and you have evidence of it, don't delay. Shoot it. Hit them and hit them hard. Shoot it along with the written statement. Submit that evidence.
Okay, this must have more a strategical approach than exactly like a one generic approach for.
There's no straight jacket formula.
Yeah, yeah. One question from my side. There are a lot of cases in which the FIR is actually filed after 1 year, 2 years, in some cases 7 years, in some cases even after 18 years. After 18 years, there is a wife who is actually complaining about the husband that he has actually harassed her at the time of their marriage, asked for dowry. God knows how that IO has actually even taken that complaint, but welcome to India. So in these type of cases, even though it's so simple for any prudent man to understand, it's actually like near impossible to prove such an allegation. Why are the courts actually entertaining this thing, and what exactly we can actually do for the courts to make this process either efficient or stop this sort of abuse?
See, understand this. First of all, as you said, welcome to India, right? Number one. Number two is, I would say in such scenario, pressurize the police to book an FIR, finish off the trial fast, and come out as innocent. That's it. Or
Okay.
see, there are few states. See, Punjab and Haryana, AP and Telangana, they have dowry prohibition rules. Dowry prohibition rules overrule the Bear Act, Dowry Prohibition Act. So use them to your advantage. While you discharge or quash, take notice of, and then get out of it fast.
Hello, Bharat sir.
Yes, Rudy.
You are saying get rid of fast. He said welcome to India. And in India it's
Okay.
possible.
In India, but that it's faster than the trial.
After then trial, that means half decade
Yeah, half decade. Yes,
to reach trial.
yes, to half decade to reach trial. Unless you force the court to frame charges, and then you keep running behind the court, asking for early dates. It depends on the defense counsel and his face value also.
Yeah, meanwhile, we have got two more questions, sir. In 125 CRPC and DV, they are actually civil cases. So the CPC order 11 rule 1 states plaintiff shall file a list of all documents and photocopies of all documents. What evidence should the husband in written statement mention and what to exclude?
I would recommend them to go through the written statement webinar.
Okay.
They can get back to me.
Yeah, we have actually covered it in detail in that webinar. Yes. And Balaji is actually asking if at all, if somebody can clarify the pros and cons of going for a speedy trial. Probably, yeah, this is a suggestion for our next webinars. We will actually make sure we will
See,
consider.
speedy trial, see, you can file for a speedy trial provided you're armed with all the weaponry. Criminal trial is a game of strategy. Figure out what the opposition wants and do exactly the opposite thing. As I keep saying, read The Art of War and Chanakya. Do exactly the opposite thing which the opposition is either expecting or behaving. Don't give them what they want.
Okay, we are still getting questions on. So, if there are 10 names in list of evidence given by OP, but 161
Then,
statements on 10 names, like if there are 10
okay.
people listed in evidence given by OP, but 161 statements only for wife and her father, mother are recorded, no 161 statements for others were recorded. Is it okay, or should we challenge it at?
Why challenge it?
Okay.
Don't alert them.
Yeah. And in the case of events in charge sheet that actually happened outside of India, and it's only the oral evidence of the complainant, how to handle this from the defense side?
First point, I would recommend them to read CRPC 188. CRPC 188 says that trial of offences that happened outside India cannot be conducted without the permission of the central government. They can go for quash for events relating to offences that happen outside India. Simple.
Okay. Where can we file for speedy trial? We have this question from Mahesh.
Very simple. First of all, try it in the same court. If not, get a speedy trial order from the High Court.
Okay, and we have one more question. Like uh, Anuj, his wife has actually filed 498 125 DV last year, and seems like she filed again a fresh complaint. So the SI came to his house for investigation. Uh, like,
How can
is
he
this
come without
possible?
giving
Or
it? How can he do that without sending a 41A? If this fellow is willing to fight, he can definitely file a writ of mandamus.
mandamus? Okay.
Because if at all there is a complaint, there are two things. One is she has given information, let him book an FIR and send a 41A.
Okay.
Or else, if he wants to call him for counseling, he has to give a 91 or 91 CRPC 91 read with CRPC 160 statement 160 notice. How can he visit his place?
Okay.
Has he committed some murder?
So what he mentioned is he has actually given the details of the previous FIR. Uh,
Okay.
but yeah, he got to know that they had actually filed another case. He's asking whether the new case can they file like a
They can
new case,
file, but
double jeopardy. But
they
yeah,
can file,
and it
but
seems like in the new
let him look
case,
at the allegations. Yeah, go ahead.
yeah, like in the new complaint, four new names of relatives are also added. So might be if the relatives are there, it could have been 498
Improved
only. So he's
allegations.
asking two 498s. Are they
Improved
possible?
allegations. Okay, he can go to definitely get the new FIR quashed, new 498 quashed.
Okay. Yeah, if at all, if the allegations are same and all those things, it actually comes under double jeopardy. Only one FIR will be the final thing which actually goes to trial, not both the FIRs.
Exactly.
Okay, yeah, that's all we have from YouTube for today. We really appreciate a lot of people actually like being really active and asking good questions today.
It was an
And a
interesting
very
webinar.
happy new year to all of them.
Happy New Year to all of you. I believe I was see thanks to the person whoever that has told asked me to slow down. I believe I'm more clear in this webinar than the previous webinars. I believe I slowed down.
Okay, thank you,
Yeah,
Bharat
brother,
sir,
sir.
for your time and efforts. Thank you very much for explaining in detail and taking up questions. Anyone has any more questions, you can please visit mynation.net. Please register and we'll answer in group. Or if you are related to this webinar, you can contact Dr. Parasar on his email or Twitter account, which given on last slide of this webinar. Thank you very much for Ramesh for taking up questions and Dr. Vikas Singh Rawat for coordinating and Vikrant Banod for the banner and other publicity. Thank you, everyone. Anyone has any more questions or want to be a want to participate in next week's Men Ki Baat, please contact us. we are there. Any question you have, any questions, you can post it to our group or WhatsApp. We are happy to answer. Thank you.
Thank you, Rudy ji. Thank you, Prasha ji.
Thanks,
And
everyone.
Thank you, Dr. Vikas. Thank
I
you, Amit.
request, yes, I like to request everyone to join our next webinar. That is going to be very important webinar for us, for all of us. So thank you for joining us. Happy New Year.
Thanks everybody for the opportunity.